Mr. Speaker, sir, I beg to move that the bill be now read a second time. Sir, in July this year, DPMTO and I made two statements in this House announcing proposed changes to our laws on drug control and murder. The amendments to the Misuse of Drugs Act, which were just passed, implement the changes announced by DPMTO. The Penal Code Amendment Bill will implement the changes announced by me. So murder is defined in Section 300 of the Penal Code, taken from the Indian Penal Code of 1860, as culpable homicide committed with one of four mental states. A, the intention to kill. B, the intention to cause injury, coupled with the knowledge that such injury is likely to cause death. C, the intention to cause injury when the intended injury is objectively sufficient to cause death. And 4, knowledge that the act by which the death is caused is so imminently dangerous that death is virtually certain or likely to result. Section 302 provides that murder shall be punished with death. Clause 2 amends Section 302 such that murders committed in a manner other than as set out in Section 300A will hereafter be punished with death or life imprisonment at the discretion of the court. Put up a slide showing the amendments. In addition, where the court orders life imprisonment, it is also given the discretion to order caning. For consistency, Clause 3 repeals and reenacts Section 304 to remove the option of a fine when life imprisonment is ordered for culpable homicide not amounting to murder. In other words, when the court orders life imprisonment for culpable homicide not amounting to murder, it can still order caning, but not a fine. Let me discuss the rationale for these changes, sir. They were set out in July. We are making the changes in the context of the homicide rate in Singapore, which is low, 0.3 cases per 100,000 population. In these circumstances, we think it right to introduce more judicial discretion in deciding whether the death sentence ought to be imposed for murder. That, as members will appreciate, is something that I said is our approach in the earlier debate. Where possible, where practical, where it's realistic, and where it does not substantially impact our criminal justice framework, we must move towards giving greater discretion to the courts. In fact, that covers the vast majority of our laws. And mandatory sentences should be the exception. For murder coming within Section 300A, where the court finds beyond reasonable doubt that an accused intentionally killed another, the death penalty will still be imposed pursuant to the statute mandatorily. So in this process of changing our laws, we have consulted a number of academics and criminal law practitioners. Their names are set out in annex to my speech. We are grateful for their contributions. After these amendments, all accused persons will be eligible for sentencing in accordance with the amended law. The transitional provisions are in Clause 4. They work as follows. The court which last heard the case will clarify the limb of murder under which the accused is guilty. Before the court does so, the prosecution or the accused may apply to the court to adduce further evidence as to the limb of Section 300 under which the accused is guilty, as to adduce further evidence as to the actual limb of the murder under which the accused is guilty. After the court clarifies that, it will affirm the death sentence for Section 300A cases. For Section 300B, C, and D, there will be resentencing by the High Court to decide whether to impose the death penalty or life imprisonment, and whether there should be caning in the latter case. The High Court's resentencing decision can be appealed. Those who have not exhausted their appeals against conviction can also bring an appeal at the same time. The new requirement for the Court of Appeal to confirm sentences of death, which will be introduced by the next bill, the Criminal Procedure Code, will also apply to these transitional cases. At the end of the appellate process, those still under a sentence of death will go through the clemency process. So I beg to move.
The question is that the bill be now read a second time. Mr. Alvin Yu.
Mr. Speaker, sir, the proposed amendments to the Penal Code centre on the introduction of a judicial discretion to not impose the death sentence for non-intentional killing. This marks a significant change from the former penalty regime where all forms of murder were punished with a mandatory death sentence. I welcome this change. There is a difference between someone who intends to commit murder, who will still be sentenced to death, and one who does not, but should know that the injury he intends to inflict may very well cause death. Although still wrong, it reflects a lower level of culpability which should, in the appropriate circumstances, be met with something less than the ultimate sentence of death. Sometimes judges are faced with the moral dilemma of whether to apply the law in its strictest sense and convict someone who did not intend to kill of murder, knowing that it would attract the harshest sentence on our statute books. This has sometimes led to the occasional odd result where the criteria for the accused to be convicted of the lesser offence of manslaughter, which does not carry the mandatory death penalty, to be applied in an uncharacteristically liberal way. This is not to criticize our courts, as in such cases both prosecutor and defense counsel can perceive the horns of the dilemma that the courts are perched on. The proposed amendments would hopefully put an end to such chaotic decisions. In the debate on the Misuse of Drugs Bill, which also introduced a judicial discretion to not impose the death sentence, in that case for the less serious forms of drug trafficking, there were calls by one member of the House to do away with the death penalty altogether. Another member pressed for the removal of mandatory sentences generally, arguing that the courts should have full discretion to mete out punishment according to the facts of each case. I respect those views, coming from members who are speaking from their conscience, but I do not agree with them. The Deputy Prime Minister and the Minister for Law, in their responses on the Misuse of Drugs Bill, spoke powerfully and eloquently on those topics, and allow me to add my brief comments to that debate. First, whether we should continue to have the death penalty. We are not the only country to have such a penalty, and certainly not the only developed nation who has this on our statute books. It is said to be barbaric, based on medieval concepts of retribution, and that we should temper justice with mercy in not putting even the worst offender to death. But I believe that justice and mercy is a two-way street. While we should rightfully have concern for the position of the convicted murderer or drug trafficker, what about their victims? Are they not entitled to protection under the law as well? Does this protection not require that the punishment fit the crime? And does this protection entail that the punishment be severe enough to deter others from going down the same lawless route? It is, after all, deterrence, not retribution, that guides modern sentencing policy. And the paramount objective is to protect future victims from suffering a similar fate. Seen against that backdrop, the death penalty serves a vital purpose of deterring by simply scaring would-be criminals from carrying out the most serious of crimes. In that regard, Deputy Prime Minister referred to the sharp drop in offences for kidnapping and firearms after the mandatory death penalty was introduced. In my view, it continues to be relevant to this very day. What about mandatory sentences and whether we should give judges unfettered discretion to impose the particular sentence for each case? In a parliamentary sovereign nation like Singapore, it is for Parliament to enact the laws of the land and the courts to apply them. If Parliament considers something important enough that it should require a breach of the law to be punished in a certain way, it not only can, but should do so. The paradigm example is the mandatory death penalty for drug trafficking, which has engaged this House in vigorous debate from Monday into today. In my view, it has played an integral part in our overall zero-tolerance approach to drugs that has kept Singapore largely drug-free, especially compared to other developed nations and even some of our neighbours in the region, and the Minister for Law had some sobering statistics to refer to in his reply on the misuse of drugs bill. Yet another example, lest one thinks that mandatory death sentences are only confined to sort of death penalty, is the mandatory imprisonment for rape offenders. Many of us would have come across cases in other countries where convicted rapists walk free with a fine or suspended sentence because the particular judge felt there that that was appropriate in the circumstances of the case. Amidst all the outrage and protest that such decisions provoke, one cannot help but think that the problem would have been averted if judges did not have that much discretion. What lies at the heart of mandatory sentences is the interest which Parliament deems so important to protect that it cannot be left to the discretion of individual judges. Hence, we have mandatory death sentences for drug trafficking because Parliament considers the serious damage that drugs can cause to many, many victims, including their families, demands that wrongdoers pay the ultimate penalty. Similarly, the mandatory sentences for rape and sex crimes against children are underpinned by the regard, the concern for their welfare, and the imperative of deterring criminals who seek to prey on them. We do not have those sensational outcomes that you read about from other countries where perpetrators walk away from a serious crime unscathed, in part because Parliament has seen fit to mandate the punishment to fit the crime. This is not to say that all mandatory sentences are good things, and I was heartened to note that the Minister for Law, in his opening speech on the Penal Code amendments, said that they are the exceptions rather than the rule. One may recall the attempt to clamp down on the harbouring of illegal aliens by imposing jail terms, this was under the Immigration Act, on offenders even when they had been misled by the illegal alien as to his credentials, unless the person who had let them into their home had checked his original passport and work permit. The courts had no choice but to sentence them to jail. And among those who suffered imprisonment before the law was changed were a priest and an elderly grandmother. So I do hope that the Ministry of Law not stop at the mandatory death sentences for murder, but carry out a wholesale review of the mandatory sentences in our penal code and other penal statutes to see if they are properly calibrated for the interests they seek to protect, or simply to see whether or not some of them may have outlived their usefulness. At the end of the day, The empirical data shows that Singapore has a significantly lower crime rate, especially for serious crimes, a lower recidivism rate for ex-convicts, a lower rate of drug addiction and abuse. Our criminal justice regime includes the death penalty and mandatory sentences as key features. We would tamper with that at our own peril. Mr. Speaker, sir, I support the bill.
Ms. Ellen Lee.
Mr. Speaker, sir, in Mandarin. 议长先生，我赞同刑事法典修正案。我个人觉得是时候这么做了。几年前，联合国大会上要投票通过全球暂缓死刑，该议案要求各国尊重国际对死刑的标准，并暂缓死刑。我国投了反对票。联大负责社会和人道主义事务的第三委员会以104票赞成、54票反对、29票弃权的结果，通过这个决议案，呼吁暂停适用死刑，并希望将来彻底的废除死刑。早在1994年与1999年的时候，联合国就讨论过这个议题。当时成员国的意见分歧，新任联合国秘书长潘基文曾说，联合国基于对生命权的尊重，反对执行死刑。新加坡为什么对这个话题表示质疑呢？根据中国网的报道，新加坡常驻联合国的代表指出，联合国人权宣言并没有禁止死刑。公民权利和政治权利国际的公约也规定，在还没有废除死刑的国家，可以对最严重的罪行适用死刑。他说，对许多国家而言，死刑意味着刑事司法公正，而不是一个人权的问题。我们认为，每一个新加坡公民都有权生活在一个安全、没有犯罪威胁的环境中。据我所知，有些国人认为，凡被判了死刑的人杀人放火，罪大恶极。他们都有一个共同点，那就是对社会造成了相当大的伤害跟危害，或是对社会造成巨大的经济损失。试想，受害人的亲人感受是多么的痛苦，可不是短期内可以淡化的。社会为什么要以仁慈对待杀人犯呢？但有好多国人对于刑事法典里的定义不是很清楚，里头有一条第300节，将该受惩罚杀人行为定义为4种情况下所犯的罪行：一是蓄意杀人；二，意图导致他人致命伤，并且很清楚的知道他的致命性；第三，意图导致他人致命伤使在普通客观情况下；四，意图致死他人，并且很清楚举动将会导致死亡。当前司法系统具有不完善之处，在第300节的定义之下，分辨嫌疑人是否具有明确杀人意图是很困难的。有学者指出，裁决有时缺乏一贯性。这次修改强制死刑的法律，意味着在谋杀案件中，只有具有明确杀人意图的嫌疑犯才会被执行强制的死刑。换句话说，要是法庭认为是第300节的第1节的时候呢的情况下，就会执行强制死刑。另外，也有学者认为，法庭似乎只顾虑死亡的发生， 没有仔细分辨三事的不同，以考虑严重性的区分。修改强制死刑，法院将有自行裁决权，判决嫌疑犯是被执行死刑还是被判终身监禁，而并非必须要执行强制的死刑。对我来说，有益于纠正某些不是很客观的看法，例如新加坡的法律制度过于严厉，惩罚严重，缺少适当性等。相反的，这样的修正案证明我们社会对法律的态度从开始到现在一直是很明朗的。我们用法律给予国民一个安全、没有犯罪威胁的环境，但我们也寻求法律的一贯性，并在这方面继续尽力做得更好。我国的法律以人为本，我们维护人权与平等，因此我们必须让每一个新加坡人都了解到这一点。我想问部长，会不会利用不同的方式或管道，协助国人理解这项修正案的含义，让大家清楚认识我们的社会环境不会变得不安全，或是有犯罪的威胁。谢谢。Thanks, Speaker.
Ms. Sylvia Lim.
Mr. Speaker, sir, this amendment bill makes an important and overdue change regarding the sentencing of homicide cases. Overall, this is a good step towards a more just sentencing regime for homicide, and I support it. Nevertheless, there are still serious issues requiring law review, which I believe the government should look into in due course. Sir, it is overdue but very welcome that the government recognizes that the existing definition of murder under Section 300 of the Penal Code is just too wide to justify the death penalty in every case. For instance, Section 300 Lim C has long been much criticized by academics for attracting the death penalty mandatorily. Under this limb, a person is guilty of murder if he intentionally inflicts an injury which causes death, not necessarily knowing that the injury is of a fatal nature. A classic example is a stab wound to the thigh, which many people do not realize is usually sufficient medically to cause death due to a severance of the femoral vein. In such cases, the accused person may not have intended death and may not have even known that death was likely to result from the injury. It was clearly too harsh to have mandatory death in such cases. Accordingly, I am happy to note that the death penalty will no longer be mandatory for murder under Section 300C and also for Section 300B and D, where the accused did not have a specific intention to kill. The alternative of life imprisonment gives the judge some room to give weight to the circumstances of each case. This is a progressive step to give some discretion to the courts so that any mitigating circumstances can be taken to account. Next, should the mandatory death penalty be maintained for Section 300A? During the MDA misuse of drugs debate, I had touched on the mixed nature of studies which tried to ascertain the deterrent effect of the death penalty on homicides. I had also spoken then about how the mandatory death penalty shifts power away from the courts to the public prosecutor, enabling him to determine the outcome of the case through the choice of charge. I note Minister's earlier statement during the MDA debate that former Attorney General Walter Woon's reservations about the mandatory death penalty shifting power to the public prosecutor applied particularly in the context of homicide cases. Now that the bill retains mandatory death for Section 300A, it is necessary to ask whether mandatory death is justifiable as retribution for intentional killing. Having an intention to kill is clearly more blameworthy than the mental states required under Sections 300B, C or D. After all, the accused in Section 300A intended to bring about the death of the victim. However, a closer examination of situations coming within 300A will show that an intention to kill can be present in a wide range of circumstances, which I submit should not be lumped together for the same sentence of death. At one end of the spectrum, taking the most evil of circumstances, we have mercenaries hired under contracts to kill, intending to profit from committing murder. We have also had groups who rob and kill hard-working taxi drivers with deadly weapons. Moving to the other end of the spectrum, we find more multifaceted scenarios where the accused is not inherently a killer. For instance, an accused finds a childhood friend whom he discovers has been having a long affair with his wife behind his back in his matrimonial bed and is unable to get over the betrayal despite a lapse of time. Another example is where a person who kills under a threat that his child will be killed if he does not do so will be guilty under Section 300A because the defense of duress does not apply to murder. An intention to kill can also be formed on the spot. There is no requirement for premeditation or any prearranged plan to kill under Section 300A, whereas in some other jurisdictions, murder which is not premeditated is classified as murder in the second degree. Do all accused coming within Section 300A deserve to die without exception? At the lowest, there would be a split of opinion on the matter. If I could borrow a phrase from the judgment of the then Judicial Commissioner Sundaresh Menon, now our Chief Justice, in PP and Lima Singh, 2007 2 SLR reissue 957, every killing is utterly tragic, but this does not mean that every killer is to be punished in the same way, unquote. So it is true that persons charged with murder under Section 300A will not hang if they can prove that they have a valid defense under the Penal Code. For instance, if the accused can prove that he acted in self-defense, this is a full defense leading to an acquittal. If he can show that he was provoked by something sudden and grave, he may have a partial defense, which will reduce his sentence to a long jail term. However, these defenses will only succeed if the accused is able to prove them in court on a balance of probabilities. Because the burden of proof is on him, he must convince the court and preferably find witnesses to support his case. There could well be a conflict of expert evidence, for example, on whether the accused has some mental illness which would diminish his responsibility for his actions, forcing the court to choose one expert over another. In addition, defenses are strictly worded and sometimes expect a person to behave in very measured ways. For example, for the partial defense of provocation, the accused must not have had time to cool off, which is construed strictly. So we can all agree that society should be clear that killing someone with an intention to kill ranks as among the most serious crimes. I would argue that this will still be achieved if the death sentence was available to the judge, especially since a wide range of circumstances are caught under Section 300A. As a second alternative, I repeat my suggestion that the government could consider phrasing the death penalty as a presumptive sentence for Section 300A. There are precedents elsewhere for this. For instance, in the Criminal Code of Western Australia, it is provided under Section 279 that an accused found guilty of murder must be sentenced to life imprisonment unless that sentence would be clearly unjust given the circumstances of the offence and the person, and when the person is unlikely to be a threat to the safety of the community when released from imprisonment. We should consider employing such a device here, which will still send a strong signal to society about the seriousness of the offence of murder, and yet allow judges to depart if the circumstances of the case warrant it. Some factors which could be considered by the courts for such departure include whether the accused acted under duress, whether the murder was premeditated or not, and if the accused did not carry any weapons to the scene. So next I shall move on to law reform. So while I acknowledge the significance of the changes this bill brings, I believe further reform of our homicide provisions is desirable. For instance, it remains a mystery why Section 300C should still be classified as murder when the accused need not have intended death nor known that death was likely. Even after this amendment bill, the judge could still impose death for Section 300C, which is not easy to justify. It seems more appropriate to move such situations lower down the seriousness ladder to a lesser category of homicide, which does not attract death. So as a wider law reform exercise, the government may also wish to look at the broader structure of the homicide provisions. We inherited our penal code from our colonial days, and the drafting of the homicide provisions has been criticized by no less than an eminent jurist, Sir James Fitzjames Stephen, who drafted our criminal procedure code. He labelled our homicide provisions as the weakest part of the penal code, calling them obscure and not fully thought out. His criticisms were several. Homicide itself has not been defined in the penal code, except in the context of culpable homicide. Murder is a species of culpable homicide. The definitions of murder and culpable homicide also closely resemble one another, such that it is difficult to distinguish between them. For instance, a person intending to cause injury, which is sufficient to cause death, is a murderer, but a person intending to cause injury likely to cause death commits culpable homicide, not amounting to murder. This may be why the member before me, Mr. Alvin Yu, classified the situation as chaotic. So there's also been criticism from the judges of the Federal Court of Australia, who had to apply our penal code to a homicide which took place on Christmas Island, which used to be part of Singapore territory. The case is Chong Wee Sing and To Yu Ting and R, 1989-40, Australian Criminal Reports 22. Arising from this, a law academic, Professor Stanley Yeo, has urged the Singapore legislature to act to improve the clarity of these provisions. So one option the government may want to consider in due course is redrafting the homicide provisions to exclude overlapping offences and have mutually exclusive categories. There are precedents from other countries to study, for example, the Australian states and the UK, which both had law reforms in this area. The Americans have first and second degree murder and then manslaughter. If a review is done to remove the overlap between culpable homicide and murder, I believe the law will be clearer and the public will also better understand the homicide provisions. So in conclusion, the government is moving in the right direction by this amendment bill to give the judges sentencing discretion for murder cases. It should continue to do more law reform, in particular, remove the mandatory death sentence from murder and make it discretionary. The government should also consider law reform to improve the homicide provisions.
Mr. Alvin Yu.
Point of clarification. My reference to the decisions was actually chaotic, as in Don Quixote, rather than chaotic, as in chaos. I apologize for my poor enunciation.
I'm sorry, Mr. Speaker, I must have misheard the member.
That's all right. Assistant Professor Eugene Tan.
Mr. Speaker, sir, I rise in support of this important bill that provides that in cases of murder where killing is not intentional, the court will have the discretion to sentence the accused to either death or life imprisonment. The court may also order caning in cases where the sentence is life imprisonment. This move to a discretionary death penalty regime for certain types of murder is significant. Although Singapore is not a party to the International Covenant on Civil and Political Rights, Singapore's position is that the death penalty should only be imposed for the most serious crimes. Indeed, in January 2004, in response to an Amnesty International report on the death penalty, the government asserted that Singapore, quote, imposes capital punishment only for the most serious crimes, end quote. It is also not in doubt that murder, particularly of the kind envisaged in Section 300A, is a most serious crime. So the penal code provisions on murder, however, are wide and extend beyond intentional killing. That is, murder falling within the meaning of Section 300B, C, and D of the penal code. For instance, for a Section 300C murder, it is irrelevant whether or not the accused person intended death or knew that death was likely. Put more bluntly, the applicable mens rea is that the intention to cause injury and nothing more. We inherited our penal code from British India, and while it was a revolutionary piece of legislation in the 19th century, it is time for us as an independent state to ensure that the provisions, the assumptions and presumptions that undergird the penal code are relevant and keeping with the needs of our nation and evolving societal norms. In this context, it is right that the mandatory death penalty is to apply only where there is a clear intention to kill. So the government has always insisted that the mandatory death penalty has helped to keep Singapore safe. Our no-nonsense approach towards crime has made security and order defining features of our society. While we could choose to retain the mandatory death penalty, I'm heartened that the government has taken the important first step of determining that the mandatory death penalty is not needed for all types of murders. I do not see this shift to a discretionary death penalty regime for murders as signalling that we are no longer tough on crime and that we are letting up on murders in particular. Instead, this shift to a discretionary death penalty regime is necessary if we are to retain public confidence and legitimacy in our administration of criminal justice. Giving our Supreme Court judges the discretion in sentencing in cases of conviction under Section 300B, C or D is an imperative if we are to temper justice with mercy. This judicial discretion is necessary in order for judges to weigh the relevant factors, the mitigating circumstances, and to individualize sentencing. In so doing, we are also able to give offenders a second chance in appropriate cases. So our execution figures based on the Ministry of Home Affairs data show that execution has declined significantly since the 1990s. Yet the overall crime situation has not worsened. In many respects, the crime situation has improved. It may well be that our tough stand on crime can continue to work even without the death penalty. It is also possible to argue that even before the amendments this week to the Misuse of Drugs Act and now to the Penal Code that is before the House, that we already do have a de facto discretionary death penalty regime through the availability of prosecutorial discretions where the public prosecutor may opt to avoid proceeding on capital charges in appropriate cases. Mr. Speaker, sir, we are making a necessary and important first step in moving towards the discretionary death penalty with these proposed amendments to the Penal Code. This continues a similar move to the discretionary death penalty regime under the Misuse of Drugs Act, which this House passed the relevant amendments earlier this afternoon. I welcome this calibrated move to a discretionary death penalty regime. On this note, I support the bill and look forward to regular and robust reviews to determine the need and use of the death penalty as an important part of the administration of criminal justice in Singapore. Thank you, sir.
Minister for Law.
So I thank everyone, all the members who spoke. I think all support the amendments, if that can be said to be a fair assessment or summary of the speeches. Mr. Yeo, I think, suggested that Ministry of Law review all mandatory sentences, and I think gave particular reference to, for example, the mandatory sentence that was imposed on landlords who rented out their flats or properties to illegal immigrants. Mr. Yeo may know this, but when I was a backbencher, I was one of those who was very uncomfortable with that mandatory nature of the sentence and spoke up against it. That has been my own philosophy, and we try and put that in place where possible. But I have to tell Mr. Yeo that it is beyond my purview to look at all legislation, most of which is not under Ministry of Law or Ministry of Foreign Affairs, and tell other ministries how their sentencing approach should take place if they have already in force. But we will pass the message on to the ministries. To thank the suggestion, I think it is in principle a sound policy and one that we, together with the Attorney General's chambers, try and institute to regularly look at all our legislation, particularly those which carry severe penalties, not just the mandatory death penalty, but severe penalties. So we thank him for that suggestion, and we will remind ourselves of the importance of that approach. As for Ms. Lee, I think the question at the end of the speech was whether we can educate Singaporeans to understand the nature of the amendments and that nevertheless our society and country will continue to be safe and secure. We will try. We will do our best. I think citizens' understanding of safety and security depends on a whole framework of factors, and we've got to keep them intact in that way. And we will, Home Affairs, I'm sure, will continue to pass the message on crime rates, on how we keep ourselves safe, and how these amendments impact on society. I think Ms. Lim was also supportive of the amendments, welcomed it. I think she had a number of points. First, on Section 300A, it is a fair point to say there are many different types of cases that can fall within Section 300A. Cold-blooded, deliberate, planned, gangster-style execution on one side. Killing by someone who finds out that his wife has betrayed him and then goes out and decides to kill. But the fact is, even in the latter situation, it is deliberate, cold-blooded, intentional killing. Because if it is not cold-blooded and intentional, if it is on the spur of the moment, there is a defense. Muslim knows that. If there is provocation. And there are other defenses as well. Self-defense, provocation, extreme. Courts look at those factors. But I can see, for example, that another approach is to have presumptive death sentence and then let it apply, and it's for the accused to then show why it shouldn't apply. That is a possible approach. On balance, looking at 300A to D, we have said, A, our society will view it as extremely serious, intentional killing, cold-blooded killing, deliberate, and in those situations, the mandatory penalty should apply. But for B, C, and D, we make I think, a very significant change. It's a question of judgment, I accept. Now, the suggestion that there should be further reform, we continuously review these areas. And specific to Section 300C, I do know that it has attracted a lot of commentary and a lot of attention. And likewise, it has received a lot of attention from us as well. And the group of people we consulted, I think the list has been circulated. Let me make 3 points on 300C. The first is, when we consulted, the submission that the academics gave us was that Section 300C is not likely to, in any significant way, affect the manner in which homicide offenses are dealt with. And I quote, "While it is true that a great majority of murder convictions since 1972 have been technically based on Section 300C, a study of the relevant facts and circumstances revealed that in almost all of them, a conviction under one of the three other subsections, 300A, B, and D, would have been likely." But that's, of course, not a complete answer as to why you keep 300C. I accept that. And in fact, there was a significant body of opinion when in our consultations that Section 300C ought to either be deleted or moved to some other place. In the intervening period that we had, I did not think that we should take such a major step, having reviewed it in July and putting up the bill now. A, for the reason that discretion is going to be given to the judges now to impose life imprisonment. So a judge who then decides to impose a death sentence would be satisfied on the facts that death indeed is merited, a high court judge, as opposed to life imprisonment. So that's, I think, a significant factor to bear in mind when we keep 300C. The third point I wanted to make is that indeed we are looking at a number of provisions, including Section 300C, and if we believe that it ought to be either moved or amended in some form, we will let the House know. My senior Minister of State, Indrani, has been asked by me to look at Section 300C. Now, I think Mr. Tan, as I see, accepts 300A as it stands now. That's my understanding. He understands. And our own view is that the majority of society also believe that for cases which come within Section 300A, the mandatory death penalty should apply. But as I've said on more than one occasion, we look at what the majority of society want or what is their view, but we also look at what is right. In this case, for the reasons that I've explained, we believe that it is also right at this time to keep 300A as it is. And I thank Professor Tan for his views. I'm not quite sure you had any specific question. I think you encouraged us to continue with law reform, which we will do. So in summary, if I may say this, in July I had said that the change will ensure that our sentencing framework will better balance the various objectives, which is justice to the victim, justice to society, and justice to the accused, and mercy in appropriate situations to the accused as well. So we hope that we are on the track, the right path to try and achieve that. Thank you.
The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Penal Code Amendment Bill.
Minister, committee stage what day, please?